I rise to speak on the Environmental Protection and Other Legislation Amendment Bill 2022, which amends the Environmental Protection Act 1994 and other legislation. The bill has a number of significant implications for those industries and organisations who hold environmental authorities, as well as the general community more broadly. Proposed amendments include extended investigative powers, expanded executive officer liability, significant changes to the transitional environment programs and changes to the contaminated land and EIS frameworks. The bill also makes changes to the submission process and the new decision point for the administering authority for the environmental impact statement prepared under the EP Act. A proponent for an EIS will now be required to submit with the draft terms of reference a summary of potential negative environmental impacts and the measures undertaken to avoid or minimise these. The Chief Executive may determine that the EIS cannot proceed if is satisfied that the project would contravene the law, give rise to an unacceptable risk of serious material or environmental harm, have an unacceptable adverse impact on the matter of state environment significance or a matter of national environment significance, have an unacceptable adverse impact on an area of cultural heritage significance, or there is a regulatory requirement requiring the Chief Executive to refuse the draft terms of reference proceeding. This would mean there is significant onus on the proponent to demonstrate at a very early stage that the project does not fall within these narrow grounds for rejection. Notably, cultural heritage significance is given a broad definition and includes an area of place or Indigenous cultural significance or aesthetic, architectural, historical significance, scientific, social or technological significance. Sorry, there's a bit of a word there. To the present generation or future generations. And how exactly will the department determine what area of technological significance actually is, or an area of aesthetic significance? I know Youngla Range is, and through this bill I'd like to see, we've asked the Minister Scanlon to come up to Youngla to have a look at these areas and actually look at the nature and the people of the Yui Burra in the eye and also the people that live there to give us some understanding about the Pioneer Hydro that they've suggested up there. The extreme ambiguity around the grounds on which an early refusal may be made is clear breach of section 4(3)(a) of the Legislative Standards Act 1992, which allows Parliament to make rights and liberties or obligations dependent on administrative powers only if the power is significantly defined. If the power is not significantly defined, and will leave the door wide open for government to impose additional grounds for early refusal by regulation. Early refusal of projects is not just some minor technical matter that may be delegated to subordinate legislation. These are major amendments with hugely significant consequences for both industry and submitters. The whole bill is riddled with the use of vague and ambiguous terms, including the term unacceptable risk, in relation to serious or material environmental harms. The problems of ambiguity and subjectivity in a number of the statutory criteria for what constitutes a major application has been raised in submissions, particularly by QRC. Deputy Speaker, the government's consultation process has been strongly criticised in a number of submissions on the bill. The bill was introduced on the 12th of October 2022, with submissions called for 9 a.m. on the 26th of October 2022, a mere 10 working days later. Such a rushed process is disrespectful to other stakeholders and does not accord with the principles outlined in the Queensland Cabinet Handbook, which state such a consultation is an essential element of the legislative and cabinet process. Consultation with persons or organisations external to the government is a routine part of policy development and cabinet submissions, and when developing legislative proposals, the Queensland Government is committed to consulting effectively with affected stakeholders at all stages of the regulatory cycle. And the Queensland public deserves a full and transparent explanation as to why the government considered it necessary for stakeholders to execute a confidentiality deed before the copy of the first draft exposure bill was released to them. Something that is hard to fathom, given the explanatory notes, the statement that one of the primary objectives of the bill was to improve community input and transparency. Deputy Speaker, the bill also substantially changes areas of legislation that are currently the subject of independent review into the adequacy of existing powers and penalties under the Environmental Protection Act 1994. This review into the EP Act is headed by retired Judge Richard Jones. Several components of the draft Apola Bill propose changes to enforcement provisions of the EP Act and will be considered as part of the ongoing independent review of the EP Act, including environmental investigations, environmental protection orders, offences related to environmental requirements and powers of authorised persons for vehicles and places. Changes to enforcement provision of EP Act should not be progressed prior to the completion of the independent review. Deputy Speaker, I have significant concerns around the bill's amendments to executive officer liability in section 493 of the bill. The amended section 493 substantially extends liability to historical acts or admissions without regard to the knowledge a former executive officer may have had at the time of the decision, as well as a potential intervening events beyond the influence of the former executive officer. Any enforcement regime must be fair and balanced, as well as clear and unambiguous in its application. And these new executive liability provisions are not consistent with these principles. According to the submission made by the Queensland Law Society, if this amendment passes in its current form, an executive officer will remain indefinitely liable for historical acts or omissions, and this could render such officers as uninsurable. Such a far-reaching liability provision is likely to have a chilling effect on the willingness of qualified and capable people to accept senior positions in corporations affected by these extended liability provisions. Amendment S326BA, when environmental investigation required contamination of land, it would appear that the intent of this proposed legislative change is to empower the department with broader regulatory powers to require environmental evaluations in wide circumstances. However, the proposed broadened power as drafted has potential for an environmental evaluation to be required without proper consideration of the effect on the environmental values, having regard to concentration levels of identified and measured contaminants. It would be possible for the department to require an environmental evaluation based on mere supposition and speculation, or but reasonably held opinion. At least two submitters of the Australian Prawn Farmers Association and the Barramundi Farmers Association, they expressed a certain amount of nervousness about the policy direction and the government appears to be taking with this bill. While some of the provisions that were in the first exposure draft of the bill were ultimately removed, specifically the explicit prescription of the intensity of yield limits, their original inclusion has raised a red flag for the state's food producers. Even with the changes, their concern is that the bill may still provide opportunities for further on-farm regulation, including the removal of transport and fair process of appeal. The concern relates primarily to the agricultural producers operating under the Environmental Authority, who may need to report a breach, possibly due to a big rainfall event. With this bill, the department may arbitrarily determine that this be a material change and compel operators to comprehensively modify their EA, introducing new conditions as a result and without any transparent appeals process beyond a court appeal. According to the testimony of Ms Rusco of the Australian Barramundi Farmers Association, the first exposure draft was extremely concerning. Ms Rusco, the committee that draft, talked about the control of yields that is akin to telling a banana farmer how much they can produce as a crop. We have significant concerns about the direction the bill takes, the policy framework. Ms Hooper expressed similar concerns, stating the changes that are being looked at here, given that the discretionary power to the department will mean they can, at their discretion, change the licence conditions, as my colleague Joe has said. For example, if there was a flood event and it was deemed a breach, those licence conditions can then be amended. Then we come down to the ability of the department to put that on yield or intensity. It should not matter what happens on farm. It is about what comes out of the farm. That is where the jurisdiction should be, not whether we have 5 ponds or whether we have 500. If we want to talk about the response from the department that agriculture is not subject to environmental impact statements, I point out that the new agriculture projects are very similar, if not identical, process to the EIS is undertaken in order to get the Environmental Authority. As I've mentioned, the bill indicates a policy shift within DAS that concerns us with regard to overreach, subjective decision-making and the removal of the Minister's review of refusal. With the opportunity for retrospective changes and no transparent appeals process that this bill invokes, business confidence is certainly reduced. I tend to agree with Ms Rusco's comment on the bill. It clearly contains a number of material, serious and unexpected shifts in policy by the Queensland Government, a shift that clearly raises concern for the future of the industry and food production of this state. Thank you, Deputy Speaker.